Lack? Mr. Lack, unmute yourself. Unmute.
Mute, please.
No, my lord.
Yes. Yes, number. Yes, number.
This is with regard to serial number 31.
Yes. What is this?
Second appeal 106 of 16, Lordship.
16 matters. Sorry.
One day's indulgence which is given for next week.
No days accommodation, Mr. Naik. I have also not gone through the brief. You have also not gone through the brief. We will study together. We'll read together.
Your Lordship, there's one case that I would like to mention, if with your permission.
Yes. Serial number?
Serial number 26, second appeal 146 of 2015.
Yes.
Your Lordship, in this matter, the arguing counsel, Mr. Vishal Kumar Tiwari, is not available. A
Sorry.
demise has happened in his family.
Sorry, there is Shailendra Jeet there. There is Atul Kumar. Sorry. 2016, second appeal pending today, coming for the first time under Order 41, Rule 11. That means more than 6 years. Sorry, absolutely.
Your Lordship, there has been a demise in his family.
Absolutely sorry. I am absolutely sorry. If no one appears, I will pass an order after going through the judgments.
Obliged, Your Lordship.
If it is a case of admission, I'll admit. If it is a case of dismissal, I'll dismiss.
Obliged, Your Lordship.
Yes.
From supplementary causes, serial number 1, undertaking for order, serial number 1, MA number 315020, Mr. Manish Kumar, for the appellant, Mr. DC Ghosh, for the respondent.
May I please, my lords?
Yes, Mr. Manish Kumar. What
My
was
lords,
this?
IEA is there, my lord, 5806 of 2021, my lords. Earlier, the Honorable Court was pleased to mark a step proceeding subject to deposit of check, my lords, within a period of 3 weeks before the learned Registrar General, my lords. Unfortunately, I have explained, my lords, it could not be done. 28 was the last date as per the order, my lord, 3 weeks.
Officer director to accept the check.
Now the check has left, my lords, so some more time may be given, my lords. 3 weeks time, further time may be given, my lords. It has to be revalidated, my lords.
The appellant is directed to comply the order dated 7/9/2021 within 3 weeks.
From Delhi causes, under the heading orders with defect, serial number 1, second appeal 46 of 18, Mr. Anup Kumar Mehta, Mr. Nikhil Kumar Mehta, Mr. Amit Kumar Sinha.
What are the defects? Remove the defects, 3 weeks.
Yes, my lord.
3 weeks to remove the defects.
Obliged, my lord.
Serial number 2, second appeal 57 of 18, Mr. Mukesh Kumar, for the appellant.
In this lot, court fees has to be deposited.
3
I'll
weeks. To remove
deposit.
the defects. 3 weeks to remove the defect.
Serial number 3, second appeal 55 of 18, Mr. Manoj Kumar Sinha, Mr. Nikhil Kumar.
I'm appearing in this case. But since there is a change of counsels, so we are not aware of the defects. That I'll only request that it may be listed under the heading for admission. Probably the girls, the respondent number.
Change of counsel.
I checked it out. Probably it came to my knowledge that is the appellant number 8. The girls, they will not be able to appear, and they had not appeared before the court, but they had wrongly been arraigned as appellant. So I'll be permitted. I may be permitted to.
Then file an application for deleting them.
For transposing them. Only request is इसको preemptive अभी नहीं किया जाए क्योंकि
I am not passing any peremptory order. I am not passing any peremptory order. No order is being passed. There is no peremptory order being passed from this court.
थोड़ा सा जी.
I am not passing any peremptory order. Peremptory order. I will start. Mr. Rajiv Kumar, I will start passing peremptory order when this court will sit physically and hear you face to face.
Admission में रखेंगे हुजूर. Admission
No. Let the defects be removed first.
One defect, CF is short of rupees.
There is a court fee shortage also. The remaining defects should be removed within 3 weeks.
अभी कर देंगे, कोर्ट की तो हम आज का आज ही कर देंगे अगर कोर्ट की है तो।
3 weeks, I'm giving you 3 weeks.
ठीक,
3 weeks. Remove all the defect, file all the petitions.
कोर्ट की बात है बाबू, क्या बात है?
Yes.
Serial number 4, second appeal 94 of 18, Mr. Yadunandan Mishra, Mr. Ramakant Tiwari.
Kitna defects?
One
Defects.
CF is short of.
The defect to be removed within 3 weeks. No one appears. However, the defect should be removed within 3 weeks.
Serial number 5, second appeal 103 of 18, Mr. Rahul Kumar Gupta, Mr. Akshay Verma, Mr. Akash Bhushan.
Yes, Mr.
Probably fresh stamp reporting must have been done, Your Lordship.
Yes, what are the defects?
Defect number 3, respondent number 4 of CC of degree under appeal has not been made party to the memo.
To remove the defect within 3 weeks.
Serial number 6, second appeal 118 of 18, Mr. Indrajit Sinha, Mr. Suraj Singh, Mr. Arpan Mishra, Mr. Amitabh Prasad, Mr. Ajay Kumar Shah, for the appellant.
But 3 weeks time may be given.
3 weeks.
Serial number 7, second appeal 127 of 18, Mr. Munana Yadav for the appellant.
No one appears. However, 3 weeks time is granted to remove the defects.
Serial number 8, second appeal 155 of 18, Mr. Bhaiya Vishwajit Kumar, Mr. Sachin Mahto for the appellant.
3 weeks time may be allowed, my lord, to remove it.
3 weeks as prayed for to remove the defects.
Okay.
Serial number 9, second appeal 158 of 18, Mr. Lalit Kumar Lal.
Who will appear in this case? Yes? Bhaiya Vishwajit?
My lord, I have no instruction in this case, my lord.
Amar Sinha, who is appearing in this?
Lordship, I will seek instruction, Lordship. Let it come after 2 weeks.
List this case after 2 weeks.
All right, Lordship.
Note down the case number.
Lordship. Lordship.
Yes.
Serial number 10, second appeal 369 of 18, Mr. K.C. Mahto, Ms. Ruby Yadav.
No one appears. However, 3 weeks time is granted to remove the defects.
Under the heading for orders, serial number 11, second appeal 11 of 16, Mr. Amar Kumar Mehta, Mr. Sanjay Kumar Sinha.
Lordship, in this case, I am appearing for the appellants. This is, my lord, admitted appeal and notices were issued to the respondents.
Let us see why it has come under the heading for orders.
Lordship, I could not see the office note, my lord. Extremely sorry.
No problem. For notice, 1 received by nephew, 2 received by self, received by grandson.
One is only respondent number 22 and 23 has not received the notice. Their SR is not received. Rest of them are 1710 received by nephew, are 2, 4, 6, 12, 13.
No, received. There's a endorsement, Mr. Sinha, that notice has been received by the nephew. Now the question is whether the nephew received by the nephew can be said to be a valid service.
One notice has been received by
Is there any endorsement that their parties are joint?
No, Lordship.
Then
So, my lord, I may be permitted to, my lord, take press steps, my lord.
just a minute. One nephew who has received nephew. Issue fresh notice to
respondent number 1710 by nephew.
1710.
Some by this brother, my lord. One respondent number 24 by Deva. Respondent number 20 by Patogu. Just by self, then grandson also, my lord. Son also, and husband also. There are 23.
Just a minute. Mr. Sinha, I'm keeping this in the physical hearing. You just inspect the record and see whether they are
Obliged, Lordship.
in this case under the same heading in a physical on the physical hearing date.
Obliged, Lord.
Serial number 12, second appeal 120 of 60, Mr. Sandeep Verma, Mr. Amar Kumar Sinha.
In this case, my lord, during the pendency of the second appeal, appellant number 1 died on 19/7/2018.
Okay.
And my lord, substitution petition has been filed for substituting the names of the legal heirs of the deceased sole appellant.
When did he die?
Died, my lord, on 19/7/2018. It is beyond time, lordship.
Beyond time.
Lordship.
Who is for the respondent?
Respondents have not entered their appearance, my lord. Appeal has not been admitted.
Okay. देखिए IA number so and so. Heard the counsel for the appellant. Full stop. By filing in this appeal, in this IA, the appellant seeks to substitute the deceased appellant number 1, Usar Mahato. Full stop. He has also prayed for setting aside the abatements and also prayed for condoning the delay.
Lordship.
He submits that Kausar Mahato died on 19/7/2018 during pendency of the appeal, leaving behind IA paragraph 3. So and so. So he submits that the cause of action survives and defaults upon them, the legal heirs. Full stop. The legal heirs, so substitution petition may be allowed. Full stop. Next paragraph. He stated in paragraph 4, 5, 6, 7, 8 that the said Kushal Mahato was looking after the case, and after his death, the appellant number 2 fell seriously ill and couldn't contact his lawyer at Ranchi, so that substitution petition could be filed within time. His full stop. He submits the Mrs. When did you file this?
Lordship.
Full stop. He submits that the substitution petition was filed on 19/2/2020. Full stop. Considering the prayer made and the submissions made before this court, I'm inclined to allow this IA. Delay condoned, abatement if any is set aside, name of appellant, deceased appellant number 1 be substituted, be deleted, and his place the name of the legal heirs so and so be substituted. IA allowed.
Obliged, Lordship. Obliged.
Necessary corrections to be carried out by in red ink in the cause title by the appellants within 3 weeks.
Obliged, Lordship. Obliged.
Number 13, second appeal 126 of 16, Mr. A.K. Sahni, Mr. Nikesh Kumar.
May be lordship. The notices were issued in the limitation matter, my lord, 267 days delay.
Yes. Respondent number 2 has not appeared.
The notices most probably has been served, my lord.
So, received by the nephew. Where is the nephew? The service by the nephew can be said to be a valid service. Service upon the nephew can be said to be a valid service. There is nothing to state that they are in jointness. Fresh notice.
But the respondent number 1 and 2 are the brothers, my lord. Both are brothers. Number 1 and 2, they are the only respondent, and both are brothers.
But the question is, he has not appeared.
Yes.
Let you take steps once. Respondent number 2, only respondent number 2. Respondent number 2, ordinary process requisites 3 weeks.
Yeah.
Fresh.
Serial number 14, second appeal 127 of 16, Mr. Sarju Prasad, Mr. Afaq Ahmad.
In this case, my lord, I have been appellant, my lord. In this case, notices are issued to respondent number 4, my lord.
Yes.
While order dated 18th October 2019, my lord. Notice are issued to respondent number 4, my lord. I have taken the steps, my lord.
The office has reported that the notice has been served, validly served upon respondent number 4. Full stop.
Serial number 15, second appeal 179 of 16, Mr. Lalan Kumar Singh.
Lordship, I am appealing on behalf of the Lord's appellants. Lordship, said petition has been filed, Lords. The appellant number 1 and 2 has died, my Lords. I have stated in para 1 and 3, my Lords.
Appellant number?
Lordship, appellant number 1, my Lords, namely Dinanath Sharma, who has died on Lordship 3/3/2017. And Lordship, appellant number 2, Raj Sharma, who has Lordship died on 8/10/2018, Lords.
म्यूट कर लो, जहां से आवाज आ रहा है म्यूट कर। Mr. Counsel,
Yes, my Lord.
This application is already barred by limitation.
Yes, Lord. Then, Lordship, I will file, Lordship.
Do whatever you like. Counsel for the appellant prays for some time. First up here, allow this case is adjourned. It's up to you what you want.
I have like.
Serial number 16, second appeal 193 of 16.
My lord, I am appearing in this case, my lord, for condonation of delay of 96 days, your lordship. The reason I have stated in para 4, your lordship. The
This was the respondent. Who is for the respondent?
My lord, I am appearing. My lord.
Yes, what do you have to say?
Lord, nothing.
There's 96 days delay in filing this appeal. Full stop. This petition has been filed to condone the delay. Full stop. The reasons have been mentioned in paragraph 4, wherein it has been mentioned that the appellant fell ill and suffered from jaundice and was advised rest. Medical certificate has also been brought on record. Full stop. Considering the said fact, I find that sufficient ground has been shown to condone the delay. Delay condoned. I allowed.
Serial number 17, second appeal 195 of 16, Mr. Jiten Kumar Pasari. Mr. Vinod Singh, Mr. Suresh Kumar, for respondents.
Who is appearing? Who is appearing? No one appears on behalf of the appellant. Less this case physical hearing date. Keep it.
Serial number 18, second appeal 200 of 16, Mr. Yashwardhan, Mr. Tapas Kaviraj.
May it please your lordship. My lord, there is a petition for addition of one Bibi Sahida Begum as a party respondent because she purchased the property from the only respondent, my lord, Zamiran Khatun, when this suit was allowed and the appeal was not filed. So it was not list pendants when the purchase was made. And this she never.
Just a minute. Purchase was made when?
On 1st of October 2014. 2004, 1st of October.
No, who had filed this suit?
The respondent Zamiran Khatun had filed the suit. She won the suit on 7/9/2004.
Declaration of right title in interest.
My lord. She won the suit on 7/9/2004.
Yes. Then
she sold it a few days after about a month after, on 1st October 2004. And the appeal was filed by me, the defendant appellant, on 22nd November 2004. That was also within 90 days.
So,
Within time, I think.
so Zamira Khatun was alive then?
Yes, she was alive.
Yes. So now Zamira Khatun is dead.
She died in 2017. We had no information because she was living with her bhabhi, who is the purchaser, in somewhere else.
So
I pray that the
who are,
purchaser may be.
no, purchaser cannot be added. Who are the heirs of Zamira Khatun now?
No, she
has died issueless. If she has died issueless,
issueless.
so now her interest will devolve upon whom?
My lord, then I will have to inquire. The appellant doesn't know who are the, or maybe that we will be the successor.
See, if you are the successor, as a successor, as a heir and representative, you can be added. But
then, my lord, let me inquire, my lord.
The capacity of a subsequent purchaser of the land.
Then I may be permitted to inquire, my lord. Who others are the
inquiry? This case is adjourned for 6 weeks on the request of counsel for the appellants.
And it may come in the virtual mode itself. We find it more.
As prayed also, is this case when the court starts functioning physically?
Virtual में कर दिया जाए.
No, there cannot be a virtual order now. If we start opening the courts,
let it come let it come after the
after 6 weeks.
Obliged, my lord. Obliged, my lord.
Serial number 19, second appeal 22-116, Mr. Raman Kumar Sinha, Mr. Sandeep Verma.
Lordship, in this case, my lord, during the pendency of the appeal, the respondent number 1, namely Jagdev Mahato, my lord, died on 24/6/2018. IA has been filed, my lord, for substituting the names of the legal heirs of the deceased respondent number 1, my lord.
When did he die?
24/6/2018, lordship. And lordship may kindly see, my lord, explanation has been given.
Anyone appearing? Anyone appearing?
No, lordship.
If you heard the counsel for the IA number so and so, heard the counsel for the appellant. First of this, IA has been filed to substitute the deceased respondent number 1, who died on 24/6/2018. First up. It has also been prayed in this IA to condone the delay and set aside the abatement, if any. Full stop. Next para. It has been submitted that Jagdev Mahato, respondent number 1, died on 24/6/2018, leaving behind so and so, paragraph 4, okay, of the IA, as his heirs and legal representative. First up, it has been stated that due to pandemic,
And my lord, paragraph 5, I have stated that the appellant is aged about 88 years, my lord.
The appellant is dead. Oh, sorry. Since it has been mentioned, since the appellant is aged about 88 years, an old and infirm person, he couldn't approach his lawyer within time. Further, there are the pandemic, which is COVID-19, swept the country, resulting in his resulting in delay in filing this appeal, this substitution petition. Next paragraph. Considering his submission and the nature of the appeal, I am satisfied that the delay has been sufficiently explained. Further, the cause of action survives and defaults upon the legal heirs of deceased respondent number 1. So this IA is allowed. In the name of Jagdev Mahato be struck off from the cause title, and in his place the name of so and so be added. Abatement, if any, also is set aside. First up, necessary corrections in reading in the cause title within 3 weeks. Issue notice. No, it has not been taken up.
No, no, Lordship. No, Lordship.
Notice मत कीजिए. It's not necessary.
Obliged.
Serial number 20, second appeal 229 of 16, Mr. C. Prakash Jha, Mr. Aishwarya Prakash.
I am appearing for petitioner, my lords. Substitution petition है हुजूर. IA number 643435. इसमें हुजूर ये applicant number 1 I died. namely संजय कुमार चौधरी 6/6/2021 को मरा है हुजूर.
Just a minute. IA 6435 2016. 2021. This IA has been filed for substituting the deceased. Appellant number 1, Sanjay Kumar Chaudhary,
Yes, my lords.
who died on 6/6/2000.
पाराची में भी है हुजूर.
It has been submitted that the deceased
Applicant number 2.
appellant number 1 you have stated.
Yes, applicant number 1 का स्टेटमेंट ये पारा 1 में किया हुआ है. applicant number 2 जो मरा है हुजूर उसको पारा 2 में है.
This is the appellant number 1. Whatever. Yes, can you? 1 and 2 is dead. Full stop. Further, it has been submitted that the appellant number 1 died on 6/6/2002. Leaving behind the following heirs and legal representative, paragraph 1. There's also been mentioned that appellant number 2 is also dead. And there are, who is appellant number 2?
Yes, my lord, Shefali Chaudhary, appellant number 2 has died, leaving behind no heirs.
There may be legal representative also.
उनको कोई नहीं है हुजूर, बाल बच्चा कोई नहीं है.
Died unmarried.
नहीं, उसको डिलीट कर दिया जाए हुजूर. शेफाली चौधरी को appellant number 2 जो मरी है हुजूर.
Leaving no heirs or representative. It is prayed that the name of the respondent appellant number 2 be deleted. Next paragraph. When did she die?
Yes, my lord.
When did she die? The date of Shefali Chaudhary has not been mentioned. Next paragraph. Considering the submissions, name of submission made by the council, name of Shefali Chaudhary, appellant number 2 is deleted at the risk of the appellants. Next paragraph. Since Sanjay Kumar, the appellant number 1 is dead and has left behind the following legal heirs, and the cause of action survives and devolves upon them. The deceased Sanjay Chaudhary be substituted by the legal heirs in this appeal. So and so and so. Necessary corrections made out in the cause title within 3 weeks. ऊपर में लिख दीजिएगा, just take it out. The application has been filed within 10.
Number 21, second appeal 235 of 16.
Yes, my lord. 6436 इसमें वही appellant number वही सेम है जो खाली केस नंबर appellant number. Yes, my lord. Yes, my lord. Yes, my lord. Yes. Same है जो.
Same order, huh?
Okay.
Serial number 22, second appeal 245 of 16. Mr. Vinod Kumar Dubey, Mr. Naveen Kumar.
In this case, my lord, your lordship have granted earlier time. Appellant number 1 died, my lord. I prayed for further 6 weeks time, my lord. Nobody turned up due to corona. So 160 time, one opportunity may be given, my lord. So to file a substitution, I will file the to set aside the abatement also.
Mr. Dubey, do I have any authority under the law to grant you time for filing a substitution application?
My lord.
Just tell me. Do I have any authority?
My lord.
The only authority which the law bestows upon me is to grant, is to condone the delay in filing an application, is to set aside the abatement. I can't grant you time to file a limit, an application for substitution. The time has already been granted to you by the civil procedure code.
Only to remove the defect, other defects.
It stands abated. Why it has been listed today?
I have not seen the file. So far, appellant number 1 only.
When did he die?
Nothing has come, my lord. Only I got information that I communicated to lordship. I communicated them due to corona. Nobody turned. One person is living at Calcutta who is driving the rickshaw, and I undertake if he will not come, then I will withdraw it or abated. So only I pray for one opportunity.
The entire appeal will not abate because there are other appellants.
Yes.
There is no substitution petition to substitute the deceased respondent number 1, appellant number 1. Full stop. Even the date of death of the appellant has not been mentioned. Even the council is not in a position to say as to when the appellant number 1 died. Full stop. In absence of any substitution application, this court will proceed as per law in hearing this appeal. Full stop. This case under order 41 rule 11 of the CPC after 6 weeks.
8 weeks कर दिया जाओ. 8 weeks अंदर भी फाइल कर देंगे citizen.
8 weeks.
Make much of.
Serial number 23, second appeal 247 of 16, Mr. Arvind Kumar Sinha, Mr. Nitesh Kumar. This case has been wrongly listed. It has to be listed in hearing under order 41. It is wrongly listed under the heading for orders.
This case has been wrongly listed under the heading for orders. This case under order 41 rule 11.
Serial number 24 with serial number 25. Second appeal 402 of 16 with second appeal 393 of 16.
Your Lordship may kindly take up second appeal number 393 of 2016, because in this there has been a typographical error in the order while admitting the appeal, Your Lordship.
The first one is there is no error.
No. 402 was against both the appeals arise out of two schedules of property. In the first one, which was with regard to, there was reversal of the
393.
Yes, 393, Your Lordship may see. This was with regard to the concurrent finding where the original suit for partition was decreed against me with regard to Schedule B property, and the appeal against that was dismissed by the first appellate court. That, Your Lordship, after hearing, had formulated the ground number 1, substantial ground number 1, mentioned in my memo of appeal, Your Lordship. Substantial question of law number 1 was formulated.
When?
It was same day.
Which date?
On the date on which this was 402 was also admitted.
Give me the date. Give me the date.
'39, 2021.
So this point of law which has been formulated is in respect of 402.
Yes, Your Lordship. Yes, yes.
So tell me what is 393?
Yes, yes, yes. Your Lordship may kindly see what was the point involved, that Your Lordship may kindly see. Your Lordship may kindly come to the trial court judgment, where the facts have been very short facts, very which it was
No.
admitted.
This case list essay number 393 of 2016 next week under the heading Order 41 Rule 11 along with essay number 402.
As is. But 402 has been admitted, but it may be
393 में ही order कीजिएगा along with the admitted appeal 402.
Under the heading, hearing under order 41 rule 11 of CTC, serial number 26, second appeal 146 of 15.
Your Lordship, in this case, I'm appearing on behalf of the appellants. Your Lordship, I informed this court that the arguing counsel, Mr. Vishal Kumar Tiwari, had to suddenly travel down to Jamshedpur. He was ready with the brief and he was ready for the argument as well. So let this case be put up for tomorrow. Lordship, it is the first time that it is coming under the orders, and we have not sought any adjournment before this date.
Yes, 2015 matters.
Your Lordship, let it be put up for tomorrow. That will not be a problem. He'll return back by evening, so he'll argue the matter tomorrow.
What was the suit for?
Your Lordship, I'm unaware of it. I have not gone through the file.
Who are you? What is your name?
Mudassar Nazar.
Where is Sailendra Jeet and Atul Kumar?
They're not present, Your Lordship. The file was with the arguing counsel, Mr. Vishal Kumar.
There are the name of three counsels appearing. One is
Yes,
not
Your
there.
Lordship. Your Lordship, Mr. Vishal Kumar Tiwari was prepared with the argument, and the file was also with him. But this has happened suddenly. He received the news in the morning that his uncle has expired, and he had to travel down to Jamshedpur.
A prayer has been made to adjourn this case on the ground of death in the family of the arguing counsel, Mr. Vishal Kumar Tiwari. Let this case be listed next Thursday. It is made clear no further adjournment will be granted in this case.
Obliged, Your Lordship.
Serial number 27, second appeal 443 of 15, Mr. Rahul Kumar Gupta, Ms. Niyati Shah.
Yes, Your Lordship.
Yes.
Your Lordship, this again is a appeal arises out of against concurrent finding of facts by both the courts below the original suit.
What is the prayer in the suit?
Yes, yes, yes. Your Lordship may kindly see, I'll be very brief with the fact. Your Lordship may kindly see the trial court judgment where there is a genealogical table which has been attached, running page 64. That would make the case clear of the parties. Case of the parties very clear.
64.
64. Running page 64 is a genealogical table.
Running page 64. Yes.
Yes. Your Lordship got the genealogical table. Yes. Your Lordship, the case of the plaintiff was, I am the defendant, original defendant. The case of the plaintiff was that this late Mohan Pal had two sons, Debu and Gopal. Gopal again had two sons, Karthik and Udo, and the property was recorded in the name of Karthik's son, who was Kangal Pal. That is in the name of Karthik Pal's son, the property was recorded. This is the case.
Property was recorded in whose name?
In the name of Durga Das Pal.
Son of?
Son of Karthik Pal.
In the genealogical table, there is nothing.
No. It has not been shown. But this was the case of the plaintiff. Now it was further said that he died, and the plot in question is total area of the plot in question is 21 decimals, and they say that the half of the property devolved upon the other son, that is Bodhna Pal, and that means Sabu Sarveshwar Pal and Kangal Pal, half of the property. The total area, I said that 21 decimals is the total area of the plotting which is in dispute. Half is 10.5, it devolved upon Sarveshwar Pal and Kangal Pal, and both of them, they sold it to Sitaram Marwadi in the year 1939 by registered deed. And then in 2005, his sons, his descendants again sold 6.5 decimals out of their 10.5 to the plaintiff. And
plaintiff is not the member of this family.
No.
Okay.
No. Even according to their case, Sarveshwar Pal and Kangal Pal had sold it to Sitaram Marwadi, and Sitaram Marwadi's descendants are the vendors of the plaintiff.
Okay.
Now, my case is, my case also, a sale deed was executed in the year 1990 by the Bhikru Pal, your Lordship would get. It is, yes, son of Malik.
So how did the property fall in your share?
Yes, 6 decimals was sold to me. I'm the defendant. So,
no.
Yes.
How did this share of property devolved upon Bhikkhu Marik?
It was the plaintiff's case that it was the half of the share had gone to Sarveshwar Pal and Kangal Pal, and another half they have not mentioned anything.
No, just tell me. The land was recorded in whose name?
That is not clear here, Lordship. That is not clear. Because
confusing. Let us read the judgment, trial court judgment.
Yes. Your Lordship may find. Trial court judgment itself, your Lordship may see. The case of the plaintiff, I am reading from para 2. The case of the... May I read it?
Yes.
Yes. I'm starting from the beginning where the prayer has been, relief has been mentioned. The plaintiff has brought the suit against defendant number 1 for declaration of his right, title, and confirmation of possession over the suit land described in Schedule A of the plaint. And if the plaintiff is not found to be in possession of the suit land, then the decree for recovery of possession by evicting the defendant number 1 for permanent injunction, restraining the defendant number 1 permanently to make any construction over the suit beside the cost of the suit. The case of the plaintiff in brief is that a genealogical table is appended in Schedule B of the plaint showing the tree of the tenure holders, intermediaries who were the erstwhile owners of the suit land pertaining to Khata number 133, plot number 121. According to genealogical table, one Mohan Pal had two sons, namely Debu Pal and Guptal Pal. Late Debu had two sons, Hiru and Malik. Hiru had one son, Banmali Malik, and two sons, namely Bhikhari and alias Bhiku. Late Guptal Pal had two sons, late Kartik Pal and late Bodhi alias Badnath Pal. Late Kartik Pal had one son. Here the important fact is there. Latter Kartik Pal had one son, Durga Das Pal. Late Bodhi Pal had two sons, Sabu alias Sarveshwar Pal and Kangal Pal. According to the plaintiff, the Khatian of Khata number 133 of plot number 121, area 21 decimal, stand recorded in the name of Khivatdar Durga Das Pal alone. After some time,
just a minute, just a minute.
Yes, sir.
Recorded in the name of Durga Das Pal. So Durga Das Pal is the son of Kartik Pal.
Yes, that I have found it out from the statement which have been made in the pleading.
So
That he is the son of.
Genealogical table is not correct.
They have not completely disclosed, but it has come in pleading that he was the son of Kartik.
Kartik. Kartik has got one son, that is Durga Das.
Yes, yes, yes.
And the land stood in the name of Durga Das.
Yes.
So yes,
This is the case of the plaintiff. Your Lordship, my case, I've not even said anything. I have only said that the property was sold to me in 1990. I am in possession there. So there is some. Yes, I may be allowed to read it further because this portion of both the properties purchased by the parties is from Khata number 123, plot number 121, area 21 decimal. Both the parties are claiming on the basis of two separate registered deeds.
Okay.
The plaintiff is claiming 6.5 decimal, whereas I am claiming 6 decimal.
Read that.
Yes. Yes, yes. According to the case of the plaintiff, the Khatian of Khata number 133, plot number 121, area 21 decimal stand recorded in the name of Khivatdar Durga Das Pal. After some time, amicable partition had taken place in between two branches as half and half, equal share, and as such the half portion, that is 10.5 decimal of land of aforesaid plot, came to the share of Sabu alias Sarveshwar Pal and Kangal Pal, both sons of late Bodhi Pal, and have come in possession. This is very important because my entire case is dependent on these.
Just a minute. This 10.5 decimal came in possession of Bodhi's son and
yes, Bodhi and
definitely Durga Das's son.
No. Durga Das, there's no mention that Durga Das had any son, further son. It has only come between two branches. It was 10.5 went to the share of 10.
Just a minute.
Yes.
This land originally stood in the name of Durga Das Pal.
Yes.
So if that be so,
yes.
Durga Das Pal means son of Kartik Pal.
Yes.
So if that be so, how can this property go to the branch of late Debu? Tell me.
That I'll show. That I'm not just this. Your Lordship, only one thing, because it has been mentioned that half of the property, this is very vital for the entire case. Now, the case of the plaintiff is after some time, amicable partition had taken place in between two branches. He only says two branches as half and half in equal share, and as such half portion 10.5 decimal of land of a fixed plot came to the share of Sarveshwar Pal and Kangal Pal, both sons of Bodhi Pal, have come in possession. And then he further says, during their peaceful possession, they have sold and transferred 10.5 decimals of land of aforesaid khata and plot to Sitaram Marwadi, alias Agarwal, and Kanhaya Marwadi Agarwal by registered deed of sale dated 3/7/39 and have come in possession so and so paying rent. So there are two important things why my case is dependent on these facts, that I have seen the sale deed. It only says 10.5 decimals out of plot number 121 without any boundary. There were approximately 50 to 60 plots which were sold, and this was only mentioned that 10.5 out of 21 decimals is being sold to the plaintiff, and no specific portion was sold to him. So now what the plaintiff's vendor has done, Sitaram Marwadi's son, descendants, they, without instituting any partition or without any definition by in their original sale deed, they have sold specific portion with boundary to their plaintiff. I'm reading it further here. Further case of the plaintiff is that after death of Sitaram Marwadi and Kanhai Marwadi, their sons, defendant number 2 to 6, came in peaceful possession of the said land and paying rent regularly. During physical possession, Mari Ram Marwadi and others sold 6.5 decimals of land of khata number 133, plot number 121 with boundary with a registered deed of sale dated so and so, dated to 21/4/2005 in favor of the plaintiff Rajendra Prasad, who after purchase mutation by in 2007-8 came in possession and paying rent to so and so. And then last line, your lordship, last 4 lines, from the perusal of document by defendant number 1 in that proceeding, the plaintiff has come to know that defendant number 1 is claiming his right over the suit of land on the basis of sale deed dated 26/4/1990. On perusal of that sale deed, it transpires that vendors of Angura Bala Dasya and Kalavati Dasya had obtained the land through registered partition deed dated 12/12/1977. But from perusal of the said partition deed, it clearly appears that the land under khata number 133, plot number 121 does not appear in that document and had never been allotted to vendors of the defendant number 1. So sale deed dated 26/4/1990 is a false fabricated document. And then on the basis of aforesaid document, reliefs were claimed by the plaintiff, and then it says, para 7, in this suit the defendants have appeared. These defendant number 2 to 6, your lordship, are the vendors of the plaintiff. So they have supported the case of the plaintiff and they have supported the transfer which was made by them. My case is from para number 8.
Yes.
Yes. My case is from para number 8. So I'll read from para 7 or 8, whatever your lordship directs.
Read.
Para 7 onwards. Prior to that, relief portion has been mentioned. In this suit, the defendants have appeared and filed their respective WS. The defendant number 2 to 6, who are the vendors of the plaintiff, have filed their WS on so and so, supporting the case of the plaintiff, admitting the sale deed in favor of the plaintiff and the right, title and interest as well as possession over the suit land under khata number 133, plot number 121, area 6.5 decimals, and denying the sale deed of the of defendant number 1, which is not in their knowledge. In their WS, the defendants have although made ornamental objections, but in fact they have supported the case of the plaintiff. They have admitted all the facts regarding acquisition of right, title and interest of the plaintiff on the basis of sale deed. According to them, the claim of the right, title and interest as well as possession are based on valid documents, whereas the claim of the defendant number 1 is false because the partition deed number so and so dated 12/12/1977, the land of khata number 133, plot number 121, not mentioned as allotted to the so-called vendors of the defendant number 1, and they have no right to transfer the land by virtue of the sale deed in favor of anyone According to them, the plaintiff has purchased the suit land from the rightful owner, hence he has every right, title and interest accordingly. They have further stated that the father of the defendant number 2 and father of the defendant number 3, 4 and 5 and 6 purchased the land 10.5 decimals out of khata number 133, plot number 121 with a registered deed of sale dated 3/7/1939 along with other plots of various khatas from the rightful owner as given in genealogical table of the plaint. After death of father of the defendant number 2, the father of defendant number 3 to 6, these defendants 2 to 6 came in peaceful possession of physical possession of the suit land, and having peaceful possession over the same, they have transferred 6.5 decimals of land to plaintiff Rajendra Prasad with a registered deed 21/4/2005, and these plaintiffs after purchase constructed boundary wall in presence of these defendants. The defendant number 1, Sharda Prasad Verma, has appeared and filed his WS on 25/11/2010, stating that the suit is not maintainable. In fact, in law, this ornamental pleas have been mentioned in this para 8, and then further it is stated that the plaintiff has filed the suit with malified intention and the plaintiff has no manner of concern as right, title, interest over the Schedule A land, as entire ground pleaded by him is false and frivolous. The suit is undervalued and valuation should not be less than 1,50,000. He categorically dealt with the allegations made by parawise of the plaint. Accordingly, according to the case of the defendant number 1, land of khata number 133 was recorded as Abad Malik under khata number 9/1 in the name of Durga Das 1, Anna and Dhobu Pal and Kangal Pal, sons of Bodhi Pal, and was ijmal in between the aforesaid 3 persons and not in the name of Durga Das Pal alone. Regarding the description of the genealogy of the Pal family in para 3 of the plaint, he has further stated in para 15 of the WS that he has no knowledge regarding the parentage of the plaintiff is put to strict proof. He does not know who was Sarveshwar Pal. According to him, Bodhi Pal had 2 sons, Dhobu and Kangal Pal, and the fact regarding partition and allotment is false. In para 16, he has further said that this defendant has no knowledge regarding parentage of Bodhi Pal and others. According to him, genealogical table given by the plaintiff is false, having any manner of concern with Schedule A land, and it is crystal clear that the land is in Chas Moja, deed number so and so, dated 1938, and the schedule is not under Chas Moja as alleged. The deed was not acted upon. The alleged deed is itself collusive, fraudulent, and as such not referred in partition deed of the year 1977. The plaintiff is not bona fide purchaser, rather he has purchased litigation. He has denied the alleged fact that he ever tried to dispossess him but failed in so.
Gupta,
Yes.
Mr. Gupta, you have vented claims through the partition deed. You have vented
Yes.
claims through the partition deed, which is of 1977.
Yes.
Whereas the sale deed of this Agarwal is dated
39.
So how can a property which was sold in 39 be a subject matter
Exactly. If your lordship, only one thing, the trial court and the appellate court, what they have done, they have focused the entire merit of the case on the defendant's case, whereas they have completely forgotten that the total area of the plot was 21 decimals, and it was for the plaintiff, only one thing, it was for the plaintiff to have clearly established that 10.5 which was partitioned between the parties, and there was specific portion which was allotted to his vendors.
When?
That is not there. I've seen the sale deed. It only says undivided 10.5 decimals.
Now tell me. You are claiming this property from whom?
From the branch of that I had shown.
And the second question is it your case? Is it your case that both the property, the property which is covered by your deed and the deed of the plaintiffs are same?
They now, yes.
No, no,
Why
tell
I
me.
say
I'm asking you. Is it the same or it is different?
there's no such, no
It is
such.
same. It is same. As per the pleadings, it is same. Okay.
As
So now, when the plot is same, the sale date by which they have purchased is of the year 1939,
absolutely,
and yours is of after 77.
absolutely.
So now they have proved that this property devolved upon their vendors.
Exactly, this is what my the substantial question of law is, that the origin starts from 1939 deed. If the plaintiff is able to establish that this is the same property was allotted, then I have no case whatsoever.
No.
It was transferred.
There's no question of same property. There's not a question.
No, Your Lordship, therefore I say, Your Lordship,
Mr. Just ask me, just tell me one thing. Is it your case that the property is different?
no, the origin, Your Lordship, because I'm on the property on the basis of a registered document which is there on record. I'm there since 1990. So if a person who has better title than me, only he can evict me.
Yes.
So for that, the plaintiff has to stand and fall on his own footing.
The land is recorded in whose name?
Land is recorded in, therefore I said, it was
exclusively in the name of Durgadas Pal.
No, that is disputed. By me in my written statement, I have shown.
But both the courts have given a finding that is recorded in the name of Durgadas Pal.
No, they have not said. They have said what they have said. They have said that it had.
Come to page 50, internal page 21 at page 57.
Internal page?
21 at page 57. Trial court judgment. Read from the third line.
Yes, it is crystal clear that land covered under so and so stands recorded in Durga Das Pal so and so. So and so.
Now tell me, give me the genealogical table. Durgadas Pali, the land is recorded in the name of Durgadas Pal.
Yes.
And father of Durgadas Pal is Gopal Pal.
Yes.
No, Kartik Pal. Kartik Pal.
Yes.
Now, Kartik Pal father is Gopal Pal.
Yes.
Now, Gopal Pal's brother is Devu.
Yes.
Your vendor is through Devu.
Yes.
Then how can this property go to
Your Lordship, in 1977 deed, the plaintiff also has. Yes, I'll show that deed. Your Lordship, there
was 39 sale.
But that
you first overcome this 39 sale.
Yes, I'll overcome that also. In 1939, that deed is the basis of the plaintiff's sale.
Yes.
Absolutely. Then that deed only says that undivided 10.5 decimals is being sold.
Even if it is undivided, even if it is divided, how can you get the share? Tell me.
But Your Lordship, there is no transfer with regard to the other 10.5.
How even if there is no transfer, how can you see, Mr. Gupta? Just
I'll answer Your Lordship's query.
If you are not understanding the query, then you can answer it properly. First, understand the query. The land is exclusively in the name of son of Kartik Pal.
Yes.
So now, this property, if it is partitioned, it will be partitioned between whom? Tell me.
Your Lordship, there was a partition in the year 1977 amongst all the heirs, amongst everyone of Mohan Pal, all the descendants of Mohan Pal.
Before that, this land was sold.
But in that, the purchaser, this Agarwal, was also a party to that partition deed. He did not show it that it was allotted to him. In that 1977 deed, the partition...
Will that partition confer title? Will that partition confer title when the land was sold to some other person? Will that deed confer any title?
He is joining in that partition on the basis of the properties which were purchased by him. That is not.
Do you mean to say he has given up his title? He has stopped from saying anything, coming up with some plea. Do you think he has given up his title by virtue of this partition deed?
Only one thing. My only plain and simple submission, Your Lordship, is that if I am in possession of a particular property, only a person.
This appeal has been filed challenging the judgment and decree passed in title suit number 28 of 2010 and the concurrent judgment passed in title appeal number 6 of 2014. Judgment. Next paragraph. The appellants herein are the defendants, appellant before the trial court and the appellate court. Full stop. Next paragraph. The suit was instituted by the plaintiff, claiming for declaration of right, title, interest, and confirmation of possession over the suit land described in Schedule A of the plaints. And a further prayer has been made that if the plaintiff is not found in, and also for confirmation of possession, and also a prayer that if the plaintiff is found to be dispossessed, a degree for recovery of possession by evicting the defendant number 1. Full stop. The suit was decreed in favor of the plaintiff. Full stop. The defendants challenged the same in a title appeal, which was also dismissed, resulting in this appeal. Full stop. Next prayer. It is the case of the plaintiff that the Khata number 133, plot number 121 is recorded. Plot number 21 having area of 21 decimal stands in the name of Durgadas Pal alone. Full stop. The land was, after the said settlement, the heirs of this Sabu Ali, Sarveshwar Pal and Kangal Pal in the year 1939 sold 6.5 decimal.
The original sale of 39. Yes, 6.5. No, original sale was 10.5.
10 sold this 10.5 decimal of land to Maliram or Kanailal. Sold to Sitaram
Marwadi
alias Agarwal. Full stop. Out of the said land, the heirs of Sitaram Marwari sold 6.5 decimal of land to the plaintiffs. Full stop. It is a case of the plaintiff that the defendants are interfering with the possession of the plaintiffs over the land in question, resulting in the suit. Full stop. Next paragraph. The defendant appeared and filed their written statements stating that they have purchased the land from the heirs of
Bhikkhu.
Heirs of Bhikkhu.
Bihari alias Bhikkhu Pal.
Bihari alias Bhikkhu.
Bhikkari
alias Bhikkhu Pal, son of Marik Pal. Full stop. It is submitted that their sale deed is dated
1990.
26th of April 90.
6th of April 1990. You have justified your fees, Mr. Pandey now. Full stop. On the lighter side, it is the case of the defendant that in the 77 there was a partition amongst the parties, and this land was also subject matter of the partition. He submit that since in partition the land fell in share of Bhikari alias Bhikkhu, his legal heirs were entitled to sell the land, and thus they have sold the land to this defendants. Full stop. Yes, this is correct.
Yes, but I have seen that deed is in Bangla. Two of my colleagues, they could not read it, that this particular plot is not.
That is difficult.
That is difficult.
Mr. Gupta, this is a partition deed. If I don't have the property, how can I partition that property? The property was sold much before. Take down. First up. Both the trial courts and the appellate court independently had gone through the document exhibits and the oral evidence, and thereafter held that the plaintiff has a better title, and they are and thus decreed the suit. First up. Next para. Counsel for the appellant submits that the land was partitioned by the partition deed, and since this particular land fell in the share of Bikari, Bikari alias Biku, their legal heirs are entitled to sell the same. He submits that sell the same, thus he has got a title over the property. He submits that the sale was through a registered sale deed. First up. Next para. After hearing the parties, I find that the main question is in this appeal is whether the plaintiff has got valid right title in interest of the property in question. First up. Both the courts, considering the facts of the case, has answered this issue in favor of the plaintiffs. First up. Both the courts have held that the land was solely recorded in the name of Durgadas Pal. First up. From the judgment, I find that Durgadas Pal is the son of Kartik Pal. First up. Father of Kartik Pal was late Gopal Pal, whereas the vendors of the defendants are from the branch of late Debu Pal. First up. Since the land is recorded in the exclusive name of Durgadas Pal, and there was a settlement between the brothers of Durgadas Pal, that is son of the cousins of Durgadas Pal, who are the vendors of the plaintiffs. The land devolved upon the vendors of the plaintiffs, and thereafter this plaintiff. First up. The land which is recorded in the name of Durgadas Pal further the sale had taken place in the year 1939. Full stop. The defendant's claim is that they have purchased the land from Bikari, the legal heirs of Bikari alias Bhikkhu. First up. Said this Bikari alias Bhikkhu is from the branch of late Debu Pal. First up. Admittedly, the land was not recorded jointly in the name of the ancestors of Debu Pal, so that this portion of the land can devolve upon Bikari. First up. The land which has not even devolved upon Bikari, even if it is in the partition deed, even if it is mentioned in the partition deed, no title will flow from it to the heirs of Bikari. First up. The vendors of this plaintiff has got better title, and the chain is complete. First up. Thus, both the courts factually has held that the vendors of the plaintiffs are the owners of had title and had authority to sell the land. First up. Further, the plaintiffs have claimed right title and interest over the property in question, which is 6.5 decimal. The defendants had not whispered whether this land is the same which is governed by the sale deed which the defendants have purchased. Full stop. For the sake of argument, even if it is taken that the land is same, then the sale deed through which the Sabu alias Sarvesh, original Sabu alias Sarveshwar and Kangal Pal has sold is of the year 1939. And the deed which the defendants are claiming has the deed through which the defendants are claiming title is of the year 1990. First up. If a title has already passed on in the year 1939 in respect of some land, the sale deed of 1990 will have no effect, as the title did not remain with the seller to transfer to this defendants. Full stop. Considering the aforesaid fact, I find that no point of law is involved in this case. This appeal is thus dismissed.
Much obliged. Milord, on lighter note, Milord said something. Milord, this date, 26th of April 1990, Milord, 26th of April is a very dangerous date, Milord. I could not forget it, Milord, therefore.
Why it's a dangerous date?
It's the date of my marriage, Milord. So whenever I see this date anywhere written, Milord, it just goes, Milord. Again, on lighter note from my side, Milord.
Let Mr. Neeraj Rai, what you have said today is recorded, and it's a live streaming. It's recorded in YouTube. It will be played everywhere now. It will go viral. Just
and I'll forward this.
Then you face the
Judicial proceeding, Milord. Judicial proceeding, Milord.
It is a live proceeding. It remains. It will be in the YouTube. Now you see how your statement.
It can be used. It can be used against you.
Milord, anyways, Milord, that your lordship's extraordinary power may have it expunged.
Next. It cannot be expunged. What is the IA, Mr. Gupta?
IA for stay. Now, your lordship may kindly
not only twice, thrice or 4 times before opening your mouth in this court. Yes, Mr. Gupta.
Your lordship, that is IA for stay. Order 41 Rule 5.
The IA is also dismissed since the main appeal is also dismissed. Yes, next.
Serial number 28. Second appeal 74 of 16, Mr. Neeraj Kishore, Ms. Vandana Kumar Sinha.
In this case, Your Lordship, I am appearing on behalf of the appellant, Your Lordship. This case is filed from the office of the Learned Senior Counsel, Mr. V. Sunat, Your Lordship, and the same has been entrusted to Mr. Sandeep Verma. There is marriage ceremony in the family of Mr. Sandeep. I only pray for not today, Your Lordship.
I don't argue. What is your prayer? First tell me.
My Lord, the file is not available with me. There is a marriage ceremony in the family of Mr. Sandeep Verma, Your Lordship. I only pray for Passover for the day, Your Lordship.
Where is the name of Sandeep Verma? There is no name of Sandeep Verma in the cause list.
This case is filed from the office of the Learned Senior Counsel, Mr. V. Sunat, Your Lordship, and the same has been entrusted to Mr. Sandeep Verma. On the last occasion, on the point of limitation, Mr. Sandeep Verma has argued, Your Lordship.
There is nothing on record. It's Mr. Neeraj Kishore, Bandana Kumar Sinha, Vipul Divya.
I only pray for Passover for the day, Your Lordship.
There is no wakalatnama.
I agree, Your Lordship.
Sorry.
इसको जो Passover for the day कर दिया था, next week में इसमें argument कर देंगे.
What is the prayer? Tell me first. What is the prayer? Tell me. Just tell me. You can tell me what is the prayer. Can't you tell what is the prayer in the suit?
The suit is filed for declaration of right title interest, Your Lordship.
Okay. Then what happened?
My Lord, this is defendant's second appeal against judgment of reversal, Your Lordship.
Yes.
Suit has been dismissed, Your Lordship. Against that, appeal has been preferred by the plaintiff, Your Lordship, and that appeal has been allowed. Against that, this second appeal has been preferred, Your Lordship.
Let's see what is the appeal judgment.
इसको जो नेक्स्ट वीक रख दिया जाता है, जो इसमें आर्गुमेंट कर देंगे.
This case next week, it is made clear, on the request it is made clear that no further adjournment will be granted in this case.
Deeply obliged.
Serial number 29, second appeal 92 of 16. Mr. Abhishek Kumar, Mr. Ashutosh Kumar Singh for the appellant.
Yes, my lord, I am appearing in this case, my lord.
Yes.
Yes, my lord, the present appeal is directed against the concurrent finding of the two courts, my lord. The trial court and the appellate court has given, so far as the petitioner appellant is concerned, my lord. My lord, the case, my lord, the suit has been filed. Suit for declaration of right title interest over the property, my lord, having an area of 2.78 acres. My lord, the first part was 0.65, second part is 1.05, and third one is 1.08, my lord, by Bhudan, my lord. What has happened in this case, my lord, so far as the case of the plaintiff appellant is concerned? Your lordship, the father of the plaintiff, my lord, Kishun Ram, my lord, he has reclaimed the land of plot number 10810 of Khata number 149, my lord, of village Chuchu. My lord, subsequently, my lord, when they made an application for assessment of rent, my lord, the process for settlement of the land was proceeded, my lord, and there were three brothers of this appellant, my lord, Yugal Ram, Kedar Ram, and Murli Ram. My lord, in the year 1976, my lord, 2.2 acres of the land was settled in favor of Murli Ravidas. 2.11 acres of the land was settled in favor of Kedar Ravidas, and so far as 1.70 acres of land which was to be settled in favor of the appellant, my lord, petitioner appellant, my lord, has left the place, my lord, for his employment, and therefore the land could not be settled, my lord. Subsequently, my lord, in the year 1976, my lord, this settlement was made in favor of the brothers. Subsequently, my lord, the petitioner made an application after coming back in the year 1985, my lord. And in the year 1988, my lord, the purchase was granted, my lord, so far as 1.70. But CO, my lord, while making recommendation, has initially made 0.65 acres of the land. And on protest, my lord, 1.05 of acres of the land was added, my lord, while issuing the purchase itself. Therefore, it was 1.70 acres. And in the year 1985, 1.08 acres of the land, my lord, with the same plot itself, was settled to the appellant, my lord, by Bhudan Parcha, my lord, by Bhudan Yagya Committee. My lord, this was the plaintiff's case, my lord. So far as the state is concerned, although the written statement was filed, my lord, but no evidence has been brought on record by the state, my lord. So far as the defendant number 3 and 4, my lord, they came out with a case, my lord, that so far as the land in question is concerned, they have admitted with respect to 0.65 of the decimals of the land settled in favor of the petitioner, appellant, my lord, in the year 1976. But so far as the interpolate, they have claimed with respect to 1.70, 1.05 acres of the land, my lord, they are saying it was an interpolation with respect to that part. And they have also said, my lord, with respect to the Bhudan Yagya committee's parcha itself, my lord, that was to be a forged one. But so far as that part is concerned, my lord, no evidence has been laid with respect to that part. My lord, the London trial court, my lord, without making any issue with respect to the forgery, which is being said to be with respect to the forged document, with respect to that part, my lord, given a finding that so far as the documents are concerned, that are forged one, because in the meantime, what has happened, my lord, the proceeding was initiated before the additional collector between the respondent number 3 and the appellate. My lord, the additional collector has given finding with respect to the settlement of 1.70 acres in favor of petitioner. Subsequently, the defendant number 3 and 4 moved before the commissioner, and Commissioner Lord has given a finding that both the documents are appears to be forged one, therefore it should be cancelled. My lord, against which, my lord, the matter has been referred to the writ court, my lord, and the appellate court. The appellate court, my lord, has granted permission to take the matter before the competent civil court, whereupon the present suit has been filed, my lord. Now, your lordship will take into consideration, my lord, in absence of particulars of the pleading, my lord, in the pleading, and in terms of Order 6, Rule 4, and in absence of any evidence, my lord, the finding given by the London trial court, my lord, and affirmed by the appellate court with respect to the forgery, my lord, appears to be illegal and without jurisdiction, my lord. My lord, this is the main substantial question of law which I am submitting in the present case.
So far as 0.65, there is no dispute.
No, no. So far as that part is concerned, that remains, my lord. So far as the parcha is concerned, Bhudan parcha is concerned, it is the state, my lord, who has to come out with respect to the fact that so far as the land is concerned or the parcha is concerned, this is a forged one. It has never been settled. That has no evidence has been brought on record, my lord. Only on the presumption or the observation made by the commissioner, my lord, this finding has been given by both the courts.
How the land came to the Bhudan Yagya committee?
My lord, so far as that part is concerned, my lord, I have produced the original document, my lord, with respect to the settlement which has been made. On that basis, my lord, the rate receipts has been mutation has been made in favor of the petitioner. Therefore, if at all, my lord, the said document was to be challenged, the necessary averment should be made in the pleading, and to that effect, my lord, the evidence was required to be given by the state and the private respondent defendant itself, my lord. No evidence has been brought, my lord, simply saying yes, this document cannot be relied upon this appear because the commissioner has directed for cancellation of those documents. That was the requirement, my lord, with respect to that part. In absence of those evidences, my lord, only on the basis of presumption, my lord, the finding cannot be given. Because the orders, that in true spirit, my lord, Order 6, Rule 4 speaks about the particulars of the fraud which is to be alleged. My lord, that is to be mentioned, and in that line, my lord, the pleading is to be given. My lord, the state is the custodian of all the documents itself, my lord. They were required to file yes, it has never been settled with the Bhudan Yagya committee. And thereafter, my lord, so far as that the order, the parcha which is being said to be issued in favor of the appellant, my lord, which is being said to be forged one, my lord. Nothing has been brought on record, and only on presumption that finding cannot be given. And even the parcha which is being said to be of 1.70, my lord, is forged one, my lord. Your lordship will take into consideration if that parcha is being seen. My lord, there is an interpolation on 1.05, not with respect to 1.70. 0.65 and then 1.05 that has been added, and then the purchase has been issued for 1.70. It is not as such, the interpolation has been made on 1.70. 65 has been interpolated to be 1.70.
Initial proposal was to settle 0.65 acre.
Was the circle officer's proposal, my lord. Subsequently, my lord, when the additional collector made this, my lord, so far as the purchase is concerned, is there in 0.65 and 1.05 has been added and 1.70 has been issued, my lord.
So you say that you
My humble submission before your lordship, my lord.
Yes.
My lord, so far as the funding is concerned, my lord, unless that issue is being framed on the basis of the pleadings, my lord, the particulars has not been given with respect to the forgery, nor any evidence has been given.
Where is the finding of forgery?
Yes, my lord, that is the trial court finding at page 53, my lord. Running page 53, your lordship will see, my lord.
Read the findings.
My lord, the finding, and thus it has been held specifically in the 7-8 lines from the bottom, my lord. Thus, it has been held specifically that the record was forged and area 0.65 decibels was increased to 1.70. Well, this is the specific finding which has been given.
You read.
Lordship.
You read the findings.
Paragraph 29.
No, you read from paragraph 15 onwards.
15.
Yes.
Issue number, Lordship, can you see the issue which has been framed, that is appearing at page number 43, my lord?
Yes.
Whether it be declared that the plaintiff has rayati right and title over the suit property, and this is the issue which has been considered in page 44, my lord, finding paragraph 15. 16, my lord. As regards the oral evidence of PW1, Modi Ram stated in his deposition that the suit was brought by his brother Yugal Ram for the land of Khata number 149, plot number 10810, area 2 acres 78 decimals of village Chuchu, and further stated he is defendant number 6 in the suit. He supported the case of the plaintiff and he is giving evidence in support of the plaintiff. And further stated he belongs to scheduled caste category Ravidas and belonged to weaker section of the society, and their ancestors were in service of ex-landlord. By permission of the landlord, his father acquired land of Khata number 149, plot number 10810 of village Chuchu, which was Gair Majurwa Khas, and his father made the land cultivable and planted tea over the land. After the death of his father, he along with his brothers Jugal Ram and Kedar acquired title and possession over the land, and they filed the application in the Anchal office for assessment of the rent. But in the Anchal process of settlement was started because they have no any hukumnama or parcha of jamindari. After settlement of land area 1.70 in the name of the plaintiff, 2.22 acres in the name of this witness, and 2.11 acre in the name of Kedar Ravidas was recommended for settlement. The settlement of this witness and Kedar Ravidas was accepted, and settlement purchase was issued in the year 1976. After fulfillment of all requirement, publication, istihar, etc., 1.70 acres of land was settled in favor of the plaintiff without any objection. The suit land was always in cultivating position of the plaintiff, and he constructed well over the suit land and made suit land plain and received 1700 from the Anchal office other as grant. There is no any position of defendant number 3 and 4 over the suit land since their ancestor. At para 1 of his cross-examination stated that he acquired the land 2.22, 2.11 acre and 2.7 acre by hukumnama. At para 3 stated that the name of landlord was Kamakya Narayan Singh. At para 4 said that in which year hukumnama was granted, he don't remember. At para 5 stated that the hukumnama was granted near about 1950. At para 6 said he has filed the hukumnama in the court. At para 10 stated jamindari receipt was issued. At para 27 stated he was not a party in the case between Yugal Ram and Nabi Mia. At para 68 of his cross-examination stated Yugal Ram acquired 0.65 acre of land from the state. PW2 Yugal Ram. Plaintiff himself stated in his deposition that he has filed the suit. Suit belongs to Khata number 149, plot number 10810, area 2 acres 78 decimals, and he belongs to scheduled caste weaker section of the society, and his ancestors were in the service of landlord. He further acquired the land of village Chuchu of Khata number 149, plot number 10810 with the permission of landlord. The land was Gair Majurwa Khas. His father made the land cultivable and used to grow crop of surguja, sarso, rahar, etc. and utilized the usufructs. Since his father Kishuna was in service of Jamindar, therefore had no need to pay salami or rent to landlord, neither his father asked for hukumnama or parcha by the landlord. After the death of his father, he and brother came in possession over the land acquired by his father. We applied for assessment of rent in Anchal office for land which was in their possession. Instead, proceeding for settlement was started in the Anchal. Since we have no any hukamnama or
Bhudan Parcha is granted to whom?
Pardon, Lord?
Bhudan Parcha is granted to whom?
The appellant, my Lord.
No, I am asking generally. It is granted to whom?
My Lord, so far as the Bhudan Yag Committee is concerned, my Lord, it is being said, so far as the settlement of land is concerned.
Look at the Bhudan.
This is to the landless person. This is being granted to the landless person.
You are a landless person.
Malad, if at all, Malad, that is being seen with respect to the land which is being settled in favor of the petitioner, Malad.
Yes.
That's the year 1988, Malad. Settlement of the land, Malad, was made in the year 1988. So
Yes.
far as Bhudan Parcha is concerned, it was made in 1985.
Bhudan Parcha was of 85.
85. And so far, settlement of 0.65 recommendation and 1.70 is concerned, that was in 1988.
Bhudan Parcha is how much?
This is 1.08 acres.
1.08 acre by Bhudan.
Lord say.
In 1985. And the settlement of the year?
1988.
There is 60 plus, 65 plus.
8 plus 1.05.
65 plus 1.05.
The total comes to 2.78 million.
1988. 88. Settlement on which ground it was settled to you?
Pardon, Lord?
Why was this land settled to you in your favor?
Malad, it was started, Malad, in the year 1976.
What was the reason for settling the land to you?
Malad, that is not there, Malad, in the pleading, Malad. The reason has been mentioned, Malad, since it was in possession of the petitioner's father has reclaimed, and therefore they made an application for assessment of the rent, whereupon, Malad, the process of settlement was made, Malad. This is the case so far as the plaintiff is concerned.
.70 acre you have obtained, claiming to be a landless person. There are several landless persons who doesn't even have a 1 decimal of land. A very nice way to get the land in your name. This Bhudan land should be taken away from you. ये तो बुरा ना दीजिए तो registered to at the time of vesting of the property. At the time of vesting of the property,
yes, Malad.
Zamindari vesting, the name of your father was not recorded.
No, Malad. At that time, it was not there. In fact, it was not there, Malad. Thereafter, Malad, subsequently, the application was made.
So why the government land will be settled in your favor? Tell me.
Malad, it was this was land was, Malad, so far as the It was a Jamindar's land, my lord.
So Zamindar at the time of vesting has never mentioned in the returns that the land was given to you?
Not at all a case, my lord. That is not at all a case.
This is absolutely, there's something fishy in this entire matter.
But my lord will take into consideration that appears to be there, my lord. Now, so far as the declaration part is concerned, my lord, this is the point which is to be taken into consideration, my lord, is whether, my lord, the forged document is to be declared, my lord, in absence of any evidence to that effect, only on the basis of presumption, without even framing the issues. My lord.
This action of the government in settling land in favor in Budanyak and also the settlement all these settlements should be looked into. How a government can settle this? It's admittedly a government land after vesting.
That can be.
So how it can be settled in favor of a particular individual? Tell me.
My lord, it is being settled, my lord, so far as the public lands are concerned, my lord, the additional.
How it can be settled to a particular? Was there any public notice so that everyone could ask for settlement?
My lord, so far as that part is concerned,
this is a public property.
My lord, that fact, my lord, so far as that this pleading is concerned, my lord, the witnesses, BW1 itself has stated that after notice and istihar, my lord, the settlement of land was made, my lord.
No, how was any application called for from the public at large that these lands?
My lord, once this evidence has come, this was to be controverted by the state, my lord.
The state has connived with you.
The state has not given any evidence. Even the respondent number 3.
The state has connived. Let me see.
Respondent number 3 and 4, my lord, they are claiming their title, my lord, over the land on the basis of Hukumnama.
Now, Bhudan Yajna gave the land to you in when?
85.
85. And the settlement is?
In favor of the appellant, my lord, in 1988.
Recommendation was when?
Recommendation. Date has not been given, my lord. Initially, my lord, process was started in 1976, my lord.
Then what happened? Why it was not? When the land was not transferred to you, you left. You went.
I left the place, my lord. The settlement with respect.
When did you leave the place?
Pardon, my lord.
When did you leave the place?
My lord, at that time, my lord, it is the case, my lord. So far as the date is concerned, it was not there. In 1976, the two brothers favor, my lord. The settlement.
That is from 76 to 83. You were not there.
No, my lord.
That means you were earning somewhere else.
Definitely, my lord, it should be.
Then your primary source of livelihood is not agriculture, something else.
That inference is drawn, my lord.
So the land could not have been settled by the Bhudan committee also.
Therefore, my lord, the inference can be drawn.
I am keeping this after 2 weeks. Let me see what can be done in this case. Whether I can take larger cognizance of the issue. Is this case after 2 weeks? Let me go through it. Let an inquiry be instituted that who has been granted land in the Bhudan year and how this Bandarbat has taken place.
Yes, yes.
Serial number 30, second appeal 104 of 16, Mr. Shailendra Kumar Singh, Mr. Pradeep Gangopadhyay.
Lordship, in this case, I am appearing for the appellant, Lordship.
Yes.
Lordship, pray for not today, Lordship, because I have just no Lordship.
First, there is no because.
Lordship.
First, tell me
Previously,
something.
in this case, Lordship, Mr. Gangopadhyay was appearing, Lordship, and he is no more, Lordship. Just I have received tomorrow.
Sorry, Mr. Gangopad. Mr. Gangopadhyay, your name is also there.
Yes, Lordship. बस कल ही रिसीव किया है सर ये आज
नेक्स्ट वीक
यस कभी भी रख दीजिए प्लीज
लॉर्डशिप मिस्टर प्रदीप गंगोपाध्याय इज नो
लॉर्डशिप
my lord one prayer. I have appeared by filing a caveat, my lord. I have not received any memo of appeal. If they just give me a memo of appeal.
ये लिखे let's discuss next week.
Serial number 31, second appeal 106 of 16, Ms. Mahua Pali.
Yes, Mr. Like, what is this case?
Is it my case, my lord? That is second appeal 106.
This is second appeal 106.
Yes, my lord. My lord, the only question of law involved in this matter, lordship, is that the case of the plaintiff is, since the case of the plaintiff is that as per Kabjawari entry, he has been allotted with the lands. Whether that Kabjawari entry indicates previous partition or not. I am taking your lordship to internal page 23 of the trial court judgment.
Let me see what is your case first.
Yes. On this point, no issue has been framed. And the appellate court has also committed the same wrong, violating the provision of order 41 rule 25. Main case is based on Kabjawari entry.
What was your prayer?
There was I am taking your lordship to internal page 23 of the trial court judgment. Number one is
let us see what is your case.
Case has been discussed in paragraph 1 and 2 of the trial court judgment. Kindly see internal page 23. Present suit has been instituted by the plaintiff against the defendants with a relief for a decree of declaration of title in favor upon the suit land as mentioned in Schedule B of the plain, cost of the suit and other things. I am the plaintiff. I have lost from two courts. Now the fact that I have narrated in the plaintiff is that according to the plaintiff, brief facts of the plaintiff case is that there is a variety land measuring 16.60 acres under Khata number 87, Thana number 147, village Hurhuru, district Hazaribagh, were recorded in the name of Ragnu Teli, Uttam Teli, Gothu Teli, Shiva Teli, in separate Kabyawadi. This Kabyawadi issue is very important. Kabyawadi of the plots in the name of each of them. Only 3 plots remain as a small equal share in Thatian and separate Kabyawadi under 87. Separate Kabyawadi of 87 remained intact without disturbance. So there was this Kabyawadi entry indicates the name of my ancestors and that remained intact. That was not within the right title interest of the defendant. And now defendants have started encroaching upon the lands and they are bent upon selling the portion of Kabyawadi entry. This was given to us after partition. Now the issue is whether this Kabyawadi entry indicates previous partition or not. This has been pleaded in both the plains. I have said there indicates partition. They have said no, it is a small property. Now, if I take your lordship to para number 4 of the trial court judgment.
Yes.
Para 4 trial court issues have been settled there.
Yes.
Issue number 1, suit is maintainable or not, whether plaintiff have got valid cause of action, whether suit plaintiff is barred by law of limitation, whether suit plaintiff is barred by law of ouster, whether suit is hit under the specific relief act. All these issues have been given in my favor. Now, issue number 4.
Issue number 7 and 8. Issue number 7 and 8 is the main issue.
Yes, all issues have been given in my favor. And my lord, there is no issue with regard to the points that I have raised in the pleadings that whether Kabyawadi entry indicates previous partition or not. This, my lord, I also agitated before the appellate court. The appellate court also, my lord, has taken up this point. Ground number 2, kindly see, my lord, judgment of the lower appellate court.
Yes.
Yes, the appellant have taken the grounds appeal challenging the impugned order of the judgment of the ground, which is
the trial court has held. The trial court has held that you are not in exclusive possession of the land in question.
Yeah. If the entry has been given in my favor, giving on the basis of oral partition that has been discussed in the same paragraph of the trial court judgment, then I am possession immediately. I am in possession of those properties, and that is not the issue. Issue is whether Kabyawadi entry indicates previous partition through which I am in possession. This has not been framed in issue, and appellate court also has taken up this matter, and appellate court missed the provisions of Order 41/25, where he ought to have framed the issue and sent back to the lower court for deciding the issue. This is the main issue.
How did you prove that the partition had taken place?
Because Kabjawari entry in the record of rights, my lord.
Record of right, it is merely showing possession. Some plat in some plots, it was shown as to be possessed by different person, and in some showing is
Yes,
mine.
yes.
So if
Because
there was a
Kabja,
partition,
yes,
there be
Lord, I'm trying to explain, Lord. So I'm trying to explain. Kabja means possession.
Possession.
Kabja means possession. Kabja body entry, it points out our name in that entry. It indicates.
Then, Mr. Naik, I'm putting you a question. What about the plots which is shown to be in joint possession of all?
They are saying that there were some properties which were Ijmal.
You are saying,
Ijmal.
You are saying also.
Yes, but so far Kabjawari entries is concerned, that is our position.
Can there be a partial partition?
My lord?
Can there be a concept of partial partition?
Can there be also a concept of partial partition?
I'm asking you, what is the concept of partial partition? If a partition,
some properties have been partitioned, some property has not been partitioned. It means that partial partitions have been done. That is the only issue, my lord. That is the only issue involved in this case that has not been decided. It is yet to be decided. When both the parties are fighting,
what is the finding? Come to the finding of issue number 7 and 8.
7 and 8, yes. Issue number 7 and 8, that has gone against me. Other issues are in my favor. I'm reading it.
Very important.
4, 5, 6, 7. Look, 6 and 7, issue number 7 has been discussed in page 36 of the trial court judgment.
39. Yes, running page 39, internal page 36. To read, let us tell your junior to read.
কোথায় গেল পেজিনেশন কিছুই করা থাকে না 39 page number 39, below I'm reading the I'm reading from page number 38. As far as oral evidence related to the issue is concerned, PW1 is saying Daso Sao, who is plaintiff number 2 in this case, narrating the case story during the examination in chief, he has stated that there was a partition before survey and shares of Raghunath Teli, Jaggu Teli, Uttam Teli, Gauru Teli, and Shiva Teli are concerned in Khatian, who are their descendants remain in position accordingly. This is the case of plenty. He has also stated that Jaggu Teli got 2.99 acres of the land continued in position, which is Schedule A of the plan. He has also stated that suit land number so and so, 17 decimals, 43 decimals, and 3 decimals, respectively, total 63 decimals, which are described in Schedule B of the plan. This Schedule B of the plan is in question. The plan, according to PW1, plaintiffs are descendants of Jaggu Teli, whereas the defendants are descendants of Shiva Teli. Plaintiffs, as well as their ancestors, had sold some of the lands. They have sold some because of partition lands, According to PW1, defendants illegally raised claim over the suit land, which compelled them to issue the present suit, and the plaintiffs are in possession of the suit lands. So we are in possession of the suit lands, and our position has been recorded in Kabjabari entry, and that has come by virtue of oral partition. On that issue, there is no finding, no issue has been framed. So only my submission would be, my lord, of the Kabjabari entry, which is the main point about the parties, indicates previous partition or not. No issue has been framed. And this was heard before the appellate court also. Appellate court, instead of using the provision of 4125, decides the entire thing, mingling everything. Defendants are accepting everything.
No.
At page 42, my lord, at page 42 of the trial court judgment, kindly see, my lord, this case of the defendants. The main defense of the defense is that Kabjabari entries as alleged by the plaintiffs were never acted upon.
Yes.
That means Kabjabari entries were there in my favor.
That means there is no partition.
They are saying that there was no partition. They are saying there no partition were never acted upon. But my say whether the Kabjabari entry indicates previous partition or not. They say they are not acted upon. That means indirectly they are saying.
Mr. Laik,
Yes.
Your client should have filed a partition suit.
They ought to have, my lord, but in this judgment, my lord, what I say, they should have decided this issue. They should have decided this. Everything is going in wrong. They should have decided this issue.
No,
in this declaration.
Your prayer is only for a right title and interest.
Now, what I mean to say, my lord,
You should have
my client ought to have brought a suit for partition. I also felt, but when this declaratory suit was given, and I confirm, my lord, that already I was in Kabjawari entry because of previous partition, and that was acted upon. The defense is saying, that was, although there is a Kabjawari entry in your favor, but that was never acted upon, so I can sell any portion of that property. So let there be a decision. Let there be a decision on this entry.
Mr. Like, in the record of rights, the recording made in the possessory column has relevance only in respect of possession.
Possession.
That too, from where the rent will be collected, from whom the rent will be collected. But so far as admittedly in your case, the khatas are still joint.
Khatas were joined previously. Therefore, a Kabjawari entry was made, my position were given. Now, whether, my lord, that positions were allotted to us indicates previous partition or not, that is the main question. And this point had been raised before the lower appellate court. You will kindly see internal page 2 of the lower appellate court judgment.
Let me go to the trial court reasoning.
That ought to have been an issue. That ought to have been an issue.
Let me go through the trial
that
court
issue has not been framed, and judgments have been given on this. And below the order 41, rule 25 speaks for that. The appellate, when the matter was placed before the lower appellate court ought to have found, yes, no issue had been paid. So I am framing this issue and let it go to the trial court for deciding that issue. That is the requirement of order 41 rule 25 of the Code of Civil Procedure.
What are you saying? The appellate court framed the issue?
Yes. Kindly see, my lord. Page 20, page 2 of the lower appellate court. Kindly see.
Yes.
Kindly see, my lord.
Yes.
The grounds of appeal.
That is your ground.
1, 2, 3, 4. The court below should have framed separate issue and should have decided as to whether the Kabjawari entry made in revisional survey indicate partition or not. Now, this has been taken up by the lower appellate court also. But lower appellate court was not framing an issue, nor sending it back to the trial court for framing an issue under order 41 rule 25 CPC. As a matter remains undecided up till now. That is the only substantial question of law, lordships, in view of the facts and
both the courts have held that you have failed to prove possession over the entire suit lands in question.
हाँ तो ठीक है, वो इशू को फ्रेम करें तब हम एविडेंस देंगे, नहीं देंगे, क्या करेंगे, नहीं करेंगे, पहले इशू तो जाएं.
It's not necessary.
पहले तो इशू में जाएं, इशू तो हो, पहले तो इशू हो, उसके बाद जो हम उस पर डिसाइड करेंगे, उस पर हम मटेरियल सप्लाई करेंगे.
You have already led evidence. Without the issue, you have led evidence.
No, that is the question, my lord. That is the whole thing. Half-hearted.
Now suppose you lead evidence, and the material is already there. The material is already there to decide a particular issue, though which has not been framed. Can't decide the same?
Yes, cannot be done. That can be done.
That can be done. If both the parties know what is the dispute and they lead evidence on the dispute, and the materials are there, court can give a finding on that particular dispute, even if particular issue has not been framed. That particular issue has not been framed.
Below, what is the use of incorporating provision in order 41 rule 25?
The use is if the parties don't know the dispute and there is no evidence on that particular point. That is the use. In this case, I have seen that there are several you have led evidence on the partition. They have
हमारा इसका
denied the partition.
हमारा इसके बाद कोई point नहीं है. This is the main thing because matter has remained undecided.
And the court, no, it is decided. The court says that you have failed to prove your possession also.
That is the how what jurisdiction he has got to decide without framing an issue. Therefore, without inviting evidences. Therefore,
no, you say your case is that by way of possession you are claiming title, exclusive title, only by the recording in the possessory column.
No, my position has been declared there in Kabjawadi entry because of partition.
No.
And the defendant have no right over it.
See, first of all, let us break down. Your case is that your name is recorded in the possessory column.
Possessory column by virtue of previous partition.
Mr. Like.
Acha. ठीक है, ये position is there.
On the basis of possession. Second point, you say that I am in possession over this land in question, for which the recording is there in the possessory column. Forget about partition. We'll
ठीक है.
So now both the court says you are not in possession. Both the court says you are not in possession.
Then, my lord, I will have to bring to your lordship's notice. Then the evidences have not been read. I read just now the evidence of PW1. They are saying they are in possession. Then perversity comes.
Second appeal, you see, that's it. You see the appeal. So in all above facts and circumstances, the plaintiffs have failed to establish by way of any conclusive proof regarding possession over the suit lands.
This much is there, lordship.
So even if the recording is there, that it is in your possession, you are not in possession over the land in questions. So nothing. Dismissed. I'll dictate.
Serial number 32, second appeal, 114 of 16, Mr. Anil Kumar Sinha.
May I please, your lordship? I am for the appellant, your lordship.
Yes.
The second appeal is arising out of the eviction suit, your lordship. And the appellant lost his case in both courts, your lordship. The eviction suit has been brought by the landlord, your lordship, on the basis of, my lord, on the basis of the default of the rent, your lordship.
Default or personal necessity also.
My lord, lordship.
Under the BBC Act.
Lordship. So, sole substantial question of law involved in this case, my lord, that section 11(1)(d) of the BBC Act has not been considered by the both courts.
What is 11(1)(d)?
My lord.
Which provision?
My lord, section 11(1)(d), your lordship, of the BBC Act.
Yes, what is it?
My lord.
Read that.
Lordship.
We are building. Lease Rent and Eviction Control Act. State law. Now Jharkhand building. Yes, Jharkhand, same. Yes. This is of 2004. Yes. 11(1)(d).
11(1)(d), your lordship.
11(1)(d). Just a minute. Just a second. Yes.
Lordship. Where the amount of 2 months rent lawfully payable by the tenant and due from him is in arrears by not having been paid within the time by contract or in the absence of such contract by the last day of the month next following that for which the rent is payable, or by not having been validly remitted or deposited in accordance with section 16. With the permission of my lord, may I permitted to read the section 16, your lordship?
Yes.
The appellate authority or the commissioner may, after giving an opportunity to the parties to be heard, make an order for deposit of rent at such rate as may be determined, month by month, and arrears of rent, if any, and in case of non-compliance of this order, the appellate authority or the commissioner shall order the defense against the fair rent order to be struck off. The landlord may apply for permission to withdraw the amount of rent so deposited without prejudice to any other legal remedy to which he is otherwise entitled, and the court may permit him to do so. My lord, in the fact of this case, your lordship, the appellant is tenant since 1971, my lord, since the time of the ancestor, your lordship, and there is no contract, your lordship. And the appellant used to pay 3 months, 4 months, 6 months in lump sum amount, your lordship, and the landlord used to receive the same, your lordship. But my lord, in the year 2003, a notice has been sent that you have not paid the rent and there is personal necessity. So you are a defaulter, and after receiving the notice, my lord, the appellant immediately paid the rent, your lordship. And after receiving the same, instant suit has been filed, your lordship. And my lord, by both the court, there is no consideration of the.
So do you mean to say that the provision on the Bihar Building Lease Rent and Eviction Control Act and the defaulter, the law which is governed, it will be treated to be parametrically as same as 138. Once the notice is given and thereafter, if the amount is remitted, he will absorb your the delay or the defects will be condoned.
My lord, there must be consideration by the both courts of below in respect of the evidences laid by the parties. If the landlord is accepting the
your argument itself that he has paid the rent after the notice clearly goes to show that he were in default.
My lord,
the default is not washed out after paying.
My lord,
is there any concept of washing out of the default in the law? As 138, your check gets dishonored, you serve a notice within 30 days. On receipt of notice, if he pays the amount. So is it the same here in the BBC Act? Is there any requirement of giving notice also? Tell me. Is there any necessity of giving notice for eviction also?
My lord, since the landlord is receiving the amount lump sum in 2 months and 3 months, he never used to issue the rent receipt, your lordship. And first time, just to make out his case, my lord, he issued the receipt for only 3 or 4 months, my lord. Prior to that, no receipt has been issued by the landlord, your lordship.
Come to issue number 3.
My lord. My lord. Page 15, my lord.
Yes.
This issue is being taken up first for the sake of convenience as well as for the just and proper adjudication of the matter. In controversy of the present suit, the plaintiff has pleaded that the rate of rent rupees 250 per month, and the defendant is a habitual defaulter and he has not paid the rent for the suit premises from the month of November 2003 till the month of March 2004. The relationship of landlord and tenant between the parties as well as the rate of rent being rupees 250 per month is quite admitted. The defendant has clearly admitted in para 5 of the written statement that the rate of rent is rupees 250 per month. Yet the defendant has said that the rent was not being paid monthly, rather it was paid in course for 6 months and 3 months, and the plaintiff, in spite of receiving of rent, was not issuing the rent receipt, but at the same time the defendant has also said in para 7 of the written statement that he has already spent rupees 2000 towards repairing and whitewashing of the shop premises, and a balance of rupees 700 is still lying with the plaintiff. The defendant has also admitted in para 7 of the written statement that the rent for the month of August, September, and October 2003 was paid by him to the plaintiff on 13/11/2003, and the plaintiff had issued a rent receipt. Also, in this regard, the plaintiff has also taken a plea that he is remitting the rent to the plaintiff through money order, which was refused by the plaintiff. Thus, from the aforesaid pleadings of the parties, I find that this fact is quite admitted between the parties that on 13/11/2003, the defendant has paid the rent to the plaintiff for the month of May 2003, June 2003, July 2003, August 2003, September 2003, and October 2003, total 6 months. And the plaintiff had also issued the rent receipt to the defendant showing the receiving of the aforesaid rent. The counterfoils of the aforesaid rent receipt also has been filed by the defendant in this case, which have been marked as Exhibit 4 to Exhibit 4 by 6 without any objection of the defendant. And the defendant has also filed the counterfoils of these receipts, which goes to show that this fact is quite admitted to the defendant. Also, that the rent of 6 months was paid by the defendant at a time to the plaintiff. Now it has to be seen as to whether the rent was payable by month or not, and whether after accepting the rent for the month of May 2003, June 2003, July 2003, August 2003, September 2003, and October 2003, by the rent receipt Exhibit 4 to 4E, the plaintiff has been stopped from raising the ground of default in payment of rent or not. None of the parties have filed any agreement for showing that the rent was payable on which date, and both parties.
Mr. Sinha, your case is that your point of law which you are trying to formulate
Lordship.
is that by accepting the rent, the landlord has waived or condoned this default.
And my lord, the just to make out the case, first time the rent receipt has been issued. Prior to that, since 1971, never the rent receipt has been issued.
That is immaterial. Your case is that you also admit that you have paid rent for 6 months rent
in lump sum, my lord.
You admit.
Lord.
So, and he also admits. So, issuing rent receipt is immaterial. So, the point of law, so what is your point of law? Your point of law is that once the landlord has received the rent, even if it is after the period of default, after the default period is over, and subsequent, even if it is for the period of default, the rent is paid at a later date, that means the landlord has waived his right to evict you. This
landlord
is your
has accepted the
acceptance of the rent for the default period after the default period will be implied as a waiver by the landlord. This is your point of law.
Since he used to receive always valid in that manner, your lord.
That there is nothing. There is no contract. In absence of such contract, then what does the law says? In absence of such contract, it will be a month-to-month tenant.
My lord.
There is nothing to show that there was a contract.
No, my lord, there is no contract.
And it is a month-to-month tenant.
Lord.
Then what happens? And the point which you are trying to raise that he has already received, so you cannot be evicted. This is not a point of law, which has to be decided.
My humble submission is, my lord, since he has accepted, my lord, and he used to accept,
This
so
law is,
he is not defaulter, my lord.
this
That is my humble submission.
no. Then 2008 volume 2 GLGR. So have you vacated the same or you are still in possession?
Still in possession, my lord, there is grocery shop, your lordship, and in the cross examination, my lord, he has accepted that he is not issuing the rent receipt, your lordship.
So you should, there is a provision of law. If the rent receipt is not issued and you are paying rent, what is the provision of law?
My lord, my lord.
You
For
should,
which,
have,
my lord,
you should have approached the rent controller demanding the rent receipt.
my lord, for which, my lord, the
Yes.
the my lord, so far the amount which I have stated in my written statement in respect of the expenditure of 2000, your lordship, I have filed an HRA case under section 9 of the BBC Act before the SDM Dhanbad, your lordship. White HRA case number 21 of 2004.
Section 20 is there. If the rent receipt was not paid, not disbursed.
Yes, my lord, since it was in practice and there was,
not
due to that reason, I have not availed section 20 of the Act, your lordship.
heard the counsel for the appellant. Full stop. This second appeal, and I perused the judgments of both the court below. This second appeal has been filed by the appellant challenging the judgment dated 8 March 2011 in title eviction suit number 11 of 2004 passed by the Munsif second at Dhanbad. Further, the appellate judgment passed in title appeal number 33 of 2011 by the district judge 2 at Dhanbad is also under challenge. Full stop. Same line. The plaintiff is the plaintiff was this appellant were the defendant appellant before the trial court and the appellate court respectively. Full stop. The suit दूसरा लाइन में ले आइए दोनों का ठीक है. The suit was filed by the plaintiff praying therein to evict the defendant within bracket appellant herein from the suit premises on the ground of default. Full stop. The plaintiff, being the landlord of the premises stated that the defendant, who is the tenant, did not pay rent from November 2003 to March 2004, and thus is a defaulter in terms of the Jharkhand Building within bracket Lease, Rent and Eviction Control Act of 2000. And thus, he has made himself liable to be evicted from the premises in question. Next para. Word question, full stop. It was the case of the defendant that there was the rent was paid according to convenience, and accumulated rent of few months were regularly were paid to the plaintiff, and thus there is no question of default. It has been further mentioned that the rent of the period which is cited by the plaintiff as the default period, was paid later on, and the same was also accepted. He submits that in view of the aforesaid fact, it cannot be. He stated that in view of the aforesaid fact, there is no default. Full stop. Next para. And same line. Both the trial court and the appellate court, first appellate court, rejected the contention of the tenant, oblique appellant hearing, within bracket appellant hearing, and has held that the tenant is in default and is liable to be evicted. Full stop. Against both the judgments, this appeal has been filed. Full stop. Next para. The learned counsel for the appellant has submitted that the tenant is not a month-to-month tenant, and the rent was paid as per the convenience in lump sum to the landlord plaintiff. He submits that when the rent was paid as per convenience in lump sum, it cannot be said that the plaintiff, the defendant tenant was in default. He further submits that admittedly, the rent for the period November 2003 to November 2003 to March 2004 was paid at a later date, which was duly accepted by the landlord. He submits that acceptance of the rent which suggests that the plaintiff landlord has condoned the delay, and it will be implied that the landlord has waived his right to seek eviction on the ground of default. Full stop. Next para. After hearing the counsel for the petitioner appellant, and after going through the record, I find that the fact that the plaintiff, the defendant is the tenant and the plaintiff is the landlord is not disputed. Full stop. The issue is the tenant has stated that he used to pay rent as per convenience in lump sum to the plaintiff. Full stop. To appreciate this proposition, to appreciate this, it is necessary to refer to section 2 is that? (11) of the Jharkhand Building Release Rent and Eviction Control Act. Just go to the top and within bracket write hereinafter referred to as the said act. Section 11 deals with eviction of tenants. Full stop. A tenant can be evicted on the grounds mentioned in the aforesaid section. Full stop. In this case, since the ground is of default, it is necessary to quote section 11 within bracket 1 within bracket small d of the said act. Quote, from the aforesaid provision, it is from perusal of the aforesaid provision of law, it is clear that where an amount of 2 months of rent, lawfully payable, falls due and has not been paid within the fixed type of the contract, or on the last day of the month next following, the tenant is liable to be evicted. From the aforesaid provision, it is clear that the rent has to be paid within the time fixed by a contract, or where there is no contract, the same has to be paid by the last day of the month next following that for which the rent is payable. Full stop. In this case, the defendant is pleaded that the rent was paid in lump sum and they were not a month-to-month tenant. Full stop. If that be so, then there has to be a contract as to by what time the rent has to be paid. Full stop. Admittedly, the defendant has failed to prove that there was any contract with the landlord in relation to the time and date of paying the rent. Full stop. The provision of law, that is 11(1)(d), provides that if there is no contract, then the rent has to be paid on the very next month, on the last day of the very next month. When the rent is due. Full stop. It is an admitted case of the landlord. It is the admitted case of the tenant that next due. Full stop. Admitted case se cut off. Full stop. It is the case of the plaintiff landlord that the areas of rent were from November 2003 to March 2004. Full stop. In absence of any contract, the rent of November had to be paid by the end of December, the rent of December should have been paid by the end of January, the rent for January by the end of February, and so forth, so on and so forth. Full stop. Admittedly, this schedule was not followed by the defendant. Thus, in terms of section 11(1)(d), the defendant has become a defaulter. Both the courts have held similarly, and there is no illegality in the safe finding. Full stop. Next para. Now the next question which the defendant appellant is trying to rake up is that when the plaintiff landlord has accepted the rent of these months, these defaulting months at a later date, though at a later date, comma, the landlord is stopped from filing this suit for eviction, and it is to be held that he impliedly waived the defaults. Full stop. This issue has already been addressed and answered by this court by this court, by this court, by coordinate bench of this court in second appeal number 171 of 2007. So-and-so versus so-and-so, reported in 2008, volume 2, JLJR, page 338, within bracket Jharkhand. This court has held that in terms of the act, in terms of the Bihar Building Lease Rent and Eviction Control Act, bracket mein likhiye. Now, after the formation of the state of Jharkhand Building Lease Rent and Control Act, within bracket close, held that once a defaulter is always a defaulter, and merely acceptance of rent of subsequent months in itself will not be deemed or implied as waiver of landlord's right to seek eviction on the ground of default of rent for more than 2 months unless expressly accepted. In this instant case, there is no express acceptance. Full stop. Thus, the point which is being tried to be raised by the appellant has already been answered against the appellant. Full stop. Next para. The question here is whether the tenant was in default. Full stop. Since it is admitted by the tenant that he had not paid the rent for the defaulting months in on the last before the last date when it fell due, and this defaulting month is more than 2 comma, in terms of section 11(1)(d), they have made themselves liable to be evicted from the said premises on the ground of default. Full stop. Next para. Considering what has been held above, I find no substantial question of law for formulation. In this case, this appeal is thus dismissed. Thank you.
you.